The question is that the bill will be read for a second time. I call the member for Maitland.
Thank you, Mr Temporary Speaker, and I rise to speak on the Environmental Planning and Assessment and Electoral Legislation Amendment, Planning Panels and Enforcement Bill of 2017. And I acknowledge the contribution of the member for Coogee before it was cut short there, but I think his contention around legislation being a fairly blunt tool, if we're going to look at getting to the heart of corruption and how we address it, actually has some merit in the sense that when we have local councils being starved of resources, which is what this bill will be doing, it'll be, funneling resources for the remuneration costs and expenses of local planning, into other areas, and they should be covered by the department rather than the council, which is one of our amendments from the opposition. It's not enough just to have legislation to keep people honest. It's not enough just to have DCPs or LEPs set there. We also need to ensure that there are resources available for investigation, that those powers are there and that the resources are there to ensure that there is true accountability. And that gets to the heart of what is wrong with this legislation. This bill was put out as an exposure draft by the former planning minister, and in that exposure draft, local planning panels were to be a voluntary policy for local councils. Now this bill will, like all these other attempts by this government that are flawed to, change or supposedly reform local government in New South Wales, but ultimately fail because they always fail to address the core issues, this bill will force all councils in the Greater Sydney region and the City of Wollongong to adopt local planning panels. Now, they won't be mandatory for regional councils, including councils in the Hunter and the Central Coast or the Tweed or outside of that Greater Sydney area in Wollongong. And why is that? Because at the heart of it, the government doesn't really care about corruption. They want to have a bit of a go at looking at legislation. They want to have a bit of a talk about let's have these panels, let's set it up. But when it comes to it, they are not really concerned about stopping corruption. This is a blatant political stunt that's been put up just before the local government elections. For those of us in councils, Mr Temporary Speaker, who have been waiting for an extra year, some of us under administration, some of us with existing councillors, some of us with developer councillors working in our councils, while this government sat on its hands and failed to apprehend any of those people and stop them from doing things which are perhaps not right. We've seen this government sit on its hands. They've lost 11 members, Mr Temporary Speaker, from this place around corruption, most of those from the Hunter and Central Coast. They don't actually have the commitment there. Now, when this issue is that these panels will not be subject to ICAC investigation because they are not public officials. The government claims to have consulted ICAC about the legislation, but the best is that they can have done is consulted officers, because there hasn't been a substantive head of ICAC between the resignation of Megan Latham late last year and Monday of this week. So what kind of consultation is this really happening? And we know that this government is really poor at consultation. We remember their consultation about local government amalgamations. That was a really good consultation process, which resulted in backflip after backflip after backflip. In fact, the Barilaro, Berejiklian flip-flops are well worn in this place. We know that their consultation with councils about the failed fizzle of the Fezzle is another example of how they fail to consult properly with the community. Now, the core issues of this bill are who are going to sit on the planning panels, whether or not they'll be accountable to the people of New South Wales. And that is at the heart of it. Local councillors are accountable. There is an opportunity for them to be voted in or voted out. They have to make those decisions about what is best for their community, knowing that they will not be there next time if they do not do the right thing. And if they do the wrong thing to a degree that is corruption, then they are elected officials and they can be put forward to ICAC. And I also refer to other members in this place, like I second their concerns about the lack of resourcing for ICAC. This government talks big on corruption and how they're going to suddenly fix everything. They don't actually resource the investigative tools, the powers and the resources that are required to actually deal with it. We can all stand up hand on heart and say we don't support corruption and we want to fight it, but unless you put on the suit, Mr Temporary Speaker, you're not Superman when it comes to fighting corruption, right? You actually have to put the dollars into it and resource the organisations to do it. And time and again we've seen that if we allow those who benefit from corruption, from development applications to decide whether or not they should be approved, then it limits very much our ability to fight corruption. And this is where we get the real problem in this legislation, Mr Temporary Speaker. There is nothing to stop councillors or mayors sitting on a local panel on the next council. We've already got gerrymandered councils here, which have happened through the abominable process of local government amalgamations in this state. The minister himself will be in charge of appointing delegates, and it's not like we've ever had a planning minister who's been a problem, but you know that, ignore that. The government is just failing time and again to address corruption. You need to be strong on it. We know that there are places in the Hunter that have really been suffering as a result of corruption, and it's not just something that you read about in the newspaper. This is a thing that actually really impacts on communities. It impacts on families, and it creates real problems for them because they have planned their life to be in a community of a certain kind of structure, of a certain environment, and then a developer comes along and makes plans that don't fit within the LEP, don't fit within the DCP, and then it's passed waves through and that family's life changes forever. Now, this government has got to properly engage with local government councils. We've seen the costs that all those local councillors spent fighting this government tooth and nail on amalgamations in the courts, the amount of money they were forced to spend on legal costs in preparation for the backflips from this government should have been spent in our local communities. They should have been providing resources for our young people in libraries, they should have been providing roadworks, they should have been providing all sorts of other social and community supports. But no, they had to use it in court to fight this government's failed policies. Now, we need to make sure that the government starts listening to the community. The opposition has put up a number of amendments in this place. We want the government to follow the lead of Labor and ban real estate agents and developers from being councillors. There is a fundamental conflict in those two roles, and if the government cannot see that, then one has to wonder how they think they can see any form of corruption at all, because that is just such a basic thing. The other issue, the other notable admission from this bill, is the lack of any action on spending limits for council elections as promised by this government, and we know that this has been a core issue for councillors. You know, we had the walking ATM around in Newcastle, the developer mayor. We've had people who have funded their way into local government, and that is a disgrace. That shouldn't be the way it happens. Community representatives should come from the community. They should be not funded to be there, but voted to be there by the community because of their real and apparent and absolute commitment to the community, not how much cash they've got falling out of their pockets in brown paper bags. Now, since 2011, the government's policy in the area of local government has been ideological and partisan. It has consistently ignored the will of New South Wales people. It's past time that those opposite realise that the government serves at the will of the people, not in spite of them, and it doesn't matter how many panels they put up there, they will not clean up local government unless they put accountability back to the people. That's what we want. We want to ensure that those councils that want to have these panels, that think they're going to work, that's fine, but we need to make sure that councillors, property developers, real estate agents are not eligible to be a member of a local planning panel. We don't want the imposition of these panels on only two areas, being Greater Sydney and Wollongong. Apply this legislation to all council areas in New South Wales. If it's so damn good, put it out to everyone. Provide that the role of the local planning panels is to exercise the consent authority functions of the council and not to operate as broader planning advisory body. You know, it can't advise on other planning matters. And don't cost shift. it provide that the remuneration costs and expenses of a local planning panel is covered by the department rather than the council. And I ask, Mr Speaker, for an extension of time, as other speakers have received.
The question is that the speaker's time be extended. All that have been say aye.
Thank you.
All against no.
Thank you.
No.
All right.
The
So we've got the gag
motion
again.
is resulted in the negative.
But you gag everything because you don't want to have any real discussion.
Let's divide on it. Divide.
Yeah, we will.
You gagged your own member. Don't blame that on us.
Yeah, we will
You
divide.
gagged your own members.
No, we're dividing on it.
Division is called. Ring the